Good morning, everybody, and welcome back to the Get in Shape webinar series. I'm Mark Benicio from Partners Life, and I run the Advisor Transition Working Group at the Financial Services Council. It is my absolute privilege this morning to welcome not only Steve Burgess, who is a regular contributor to the series, but also our Privacy Commissioner, John Edwards. So it's going to be a fantastic webinar today. Before we get into the content of today's webinar, I'd just like to remind you about the series. We have been fortnightly for about the past must be 20 weeks or something with these series. The most recent webinar was on risk. The earlier webinars are available on the YouTube channel, and the link is available on this slide. And also you'll find it at getinshape.nz. So you can find all the earlier webinars at that point. The last webinar was fantastic around how to manage risk within your business. And we're very lucky today to be, we're in a situation here where the regime around financial advice is changing, and there's so much that you have to do to get your business ready for this regime. Well, at the same time, the Privacy Act is now 27 years since its last update, and as we know, technology has changed significantly in the last 27 years. So coincidentally, the Privacy Act has changed, and we are absolutely blessed to have John Edwards, our Privacy Commissioner, come along to tell us about those changes, and then Steve will talk to us about the impacts of those changes on financial advice business. So without further ado, remember, fire your questions away either through Q&A. I'll monitor those and pass those on to the speakers. So as you've got questions, please fire them along, and I hope you enjoy the webinar. Thank you, gentlemen.
Kia ora koutou katoa, ko John Edwards tēnei, te mana matapono mata tapu. Thanks for that, Mark. That just said, I'm John Edwards. I'm the Privacy Commissioner. And thank you for your interest in joining this seminar. Privacy is a big deal for us. I know that you have a lot of other regulatory requirements that you have to comply with and prepare for, so I really appreciate you taking the time to inform yourselves about the Privacy Act. Before I tell you about the changes to the Privacy Act, I think it's helpful to start with a refresher, because I know not everybody is familiar with this little corner of the law as me and my staff are. So I think to understand the regulatory approach in privacy, you first need to get your head around a couple of concepts. One is agency. That is the unit that this act applies to, the regulated bodies. Agency is defined in the Privacy Act as a person or body of persons, whether corporate or unincorporate. And beyond that very wide-ranging description, it narrows only by excluding certain entities, such as the news media in relation to their news gathering and dissemination activities, the courts in relation to their judicial functions, members of parliament, the governor general. So you take those out, and every other kind of grouping or enterprise in the economy is subject to this law. So your music teacher, your golf club, your church, your insurance company, the bank, the government departments, all of that is subject to the Privacy Act. So you get a sense of the breadth of application. The next concept is personal information. What is being regulated here? So every agency has to comply with the Privacy Act in relation to personal information. That is a term that is defined as information about an identifiable individual. Not sensitive information or private information, information that is about an identifiable individual. When you put those two things together, you see that this law reaches into every aspect of human activity across the economy. So it's incredibly, there's millions of variables. The legislators back in 1993 had to make a decision. Well, how are we going to regulate for privacy? Do we do it in a very prescriptive way and tell people what they have to do in every given circumstance? And they decided that no, that was going to get really complicated really quickly, given the infinite variety and the contextual nature of privacy. That we change one variable and the whole context changes, and you might get a different outcome or answer. So the approach that has been in the legislation since 1993 is to apply these general principles, they're called information privacy principles. They're derived from some principles that were set out by a working group of the OECD way back in 1980, when they were grappling with the question of how do we deal with the implications of this new fangled technology of the personal computer. The principles which they articulated, the New Zealand Parliament pretty much grabbed holus bolus and put into law. I'm going to take you through those just briefly as a backgrounder. They cover the sort of life cycle of personal information through an agency. So when we talk about privacy, very often people say, okay, privacy, I understand that. That's about, you don't tell people anything. You lock it down, right? And yeah, sure, that's one important element, but it doesn't make any sense unless you locate that in the context of these privacy principles, which are really about introducing kind of good hygiene and a respect for personal information in your organization. So the first one, the first four deal with the front end, collection of personal information. And we start with the what my colleagues in Europe call the data minimization principle. Only collect information that you need, right? If you don't need it, don't collect it. So yeah, you guys have an awful lot of legitimate information collection needs. You've got to do your due diligence for anti-money laundering and the like. So you're collecting quite a lot of information. You can justify all of that, but you don't add to that form. And what is your sexual orientation? You don't need that information. You shouldn't collect it. That's data minimization. Where you can get the information directly from the individual. Again, it's a high-level best practice principle. It wouldn't work as an absolute rule. We can't get through a day without breaching that principle, can we? But if you can, get it directly from the individual. I mean, the basis of this law is about kind of restoring and maintaining individual autonomy, recognizing that we hold information on trust for an individual, and it's about their dignity and humanity. So that's what we're reinforcing. Principle 3 is really important. It's being open and transparent, telling people why you are collecting their personal information, what's going to happen with it. Most of the complaints that come to my office outside of access, which I'll come to in a moment, are a consequence of surprises. Why did you do that? Why did you tell that organization? Why did you report this transaction? If people are told up front very clearly what happens as a result of entering into this transaction, they're not going to be surprised. And maybe they can choose not to enter into that transaction, not to use your services, not to take that credit or loan accommodation, weigh it themselves and say, yeah, sure, I don't mind that that agency getting access to that information for that purpose. Number 4, don't collect personal information by means that are unlawful or unfair or that intrude to an unreasonable extent upon the privacy of the individual. So that's collection, front end. Once you've got it, you've got to keep it secure. And again, the law is not prescriptive. It doesn't say what the security standards are. It just asks you to have a moving scale depending on the sensitivity of the information and what could happen if it was released. So I'm going to expect a higher standard of security when you file the identity documents of your clients than I would when you are acting in your capacity as the treasurer of the play centre and emailing the other parents of the play centre, right? The standards that you have in that business context with very sensitive information that could be misused to harm someone is higher than accidentally CCing rather than BCCing the people in your play centre group. Principle 6 is often overlooked in terms of privacy. It's not recognised much as a privacy right, but it's absolutely central. People have the right to access their information that's held by you. You have a right to know what the doctor's got about you, what the insurance company's got about you, what the bank has, what your employer has, right? It's really central. Once you've got access, if you see there are errors, you're entitled to correct it. And if it's a matter of opinion or if there's a dispute about whether the information is accurate, to add a statement of the person's version of the information. Number 8, you've got to take reasonable steps to ensure that the information is accurate before you act on it. Number 9, don't keep it for longer than you need it. I think we're going to come back to that in the questions a bit later. Number 10, use it only for the purposes for which you've obtained it. We've seen this one come under a bit of pressure as businesses have been required to collect information for purposes they've never had before, for public health purposes. Maintaining COVID contact tracing registers. There's a clear purpose limitation with that information. You don't get to use it to market your services. You don't get to use that to get a date from somebody who happened to sign in at your premises at some point. And then we get to principle 11, which is do not disclose information to another person unless that disclosure is one of the purposes for which it's been collected or is directly related to those purposes. And I think we're going to come back to just how that works. But you can also disclose it when doing so is necessary to avoid a prejudice to the maintenance of the law, or when it's necessary to avoid a serious threat to somebody, or to avoid prejudice to public health or public safety. So these principles have some flex in them, and those usually align with common sense to what you would expect to be there. We're getting a new Principle 12, which I'm going to come back to later. The 93 Act has a Principle 12 that says you should only use unique identifiers for the purpose for which they were obtained, and not assign a unique identifier for your own customers that's already been assigned to someone else. So that's the basis on which our law has worked for the last 27 years. Most of the other jurisdictions around the world have a similar lineage. They trace back to those OECD principles and follow this kind of approach of purpose limitation, data minimization, security requirements, and then constraints on use and disclosure. So if we can move to the next slide, we see people have continued to be concerned about privacy. It's been steady and rising in our surveys that we conduct every couple of years. The Law Commission reviewed the Privacy Act in light of these concerns in 2011, and well, they made their report in 2011, but they'd spent 5 years looking at it. They determined that the approach I've just described of application universally across the economy, open textured, technology neutral guiding principles is a sound approach to the law. So they said the fundamentals of the Privacy Act work well, but it needs a bit of modernizing. And bear in mind that that call for modernization is itself 9 years old. But they made some recommendations which the government accepted in 2014. And we've finally seen an act passed earlier this year, which will come into force on the 1st of December. And if you move to the next slide, there's only about half a dozen new policy elements to it. The Act has been completely rewritten, but many of the changes are cosmetic. They're stylistic, reordering, reorganizing, and modernizing the drafting language. But the new bits are these ones. First, there will be an obligation on an agency that has not met its obligation to keep information secure and experiences a privacy breach to notify affected individuals and to notify my office where that breach could cause or has caused serious harm. And serious harm is judged by reference to how sensitive the information is, how widely it's been distributed, how successful your efforts to mitigate any harms have been, how secure the information was when it was lost. So, you know, if you lose a USB stick with all your client files on it, potentially that could cause serious harm. But if it's encrypted and password protected, then obviously no one can access that information on that device when they recover it. So that may mean it's not a notifiable matter. So we might have some questions on that. We can come back to that in a minute. I'll just race through these. The rest of them are less about what businesses have to do than the powers that my office will have to enforce the Act. It's often not clearly understood that the Privacy Act 1993 has very little ability in it for a commissioner or anyone else to actually enforce the law. You know, journalists are always calling me and saying, hey, did so-and-so break the law? Are you going to punish them? What's the penalty? Well, there are no penalties and there are no punishments. That's going to change a little, not a lot, not as much as my colleagues in Europe who get to fine agencies 4% of global revenue or 20 million euros, which is ever is the greater. Not as much as in the US, where the Federal Trade Commission, which is my equivalent in relation to the private sector, got to fine Facebook $5 billion last year. So no, but we will have some powers to enforce, and that'll first be the issuing of compliance notices. So if we see conduct which is non-compliant, we'll be able to act whether someone's been harmed or not, whether someone complains to us or not. We'll be able to serve compliance notices, and that will require an agency to stop doing something or to do something in a different way. And if they don't comply, we can enforce those in the Human Rights Review Tribunal and try and get a fine of up to $10,000. There will be new criminal offences under the Act. It will be a criminal offence to impersonate someone for the purposes of gaining access to or modifying their personal information. It will be a criminal offence if somebody asks you for their personal information, for you to destroy that information in response. I will be able to make binding decisions on access requests. So at the moment about our complaint businesses on reviewing access decisions, and we just have to try and persuade respondent agencies to release information that we think should be released, but we can't force them. We will be able to do that under the new Act. The Privacy Act will apply explicitly extraterritorially, and many of you will know that term, and will know that the General Data Protection Regulation in Europe acts in the same way. That is extraterritorially. It applies to people who aren't in Europe if they are offering services to people who are in Europe. So the test for that is going to be whether an agency is carrying on business in New Zealand. And that will mean when we assert our enforcement rights against an agency, it won't be a defence to say, hey, our servers are in Dublin or our office is in Palo Alto. The test is not whether you have a legal presence in New Zealand or any employees or a bricks and mortar presence or a server. It'll be whether you're carrying on business. Are you offering services to New Zealanders? Are you collecting their personal information? Are you making money here? And I mean, that's going to come with some complexity in the enforcement, but I think it's a really important levelling of the playing field in this new borderless digital economy. There are changes to the rules about sending information overseas. And you'll need to be able to, agencies will have to satisfy themselves if they're dealing with a partner agency in another country, that personal information being sent will be protected by comparable protections that apply in New Zealand. We'll be providing some guidance and assistance on that. And a couple of new grounds for refusing someone's access to information, for example, where providing access would lead to serious harassment. So we've got some, if we move to the next slide, it's going to be important to gear up for the new Act. It's a really good opportunity to build awareness in your organisation, to make sure people are conscious of the importance of respecting the personal information. I mean, the financial services sector runs on personal information. It's a key asset that's actually not on your balance sheet. So talk to your staff, give them some training, make sure you've got a privacy officer. Think about this obligation for breach reporting. Every day things go wrong, and we have near misses, right? You leave the door open, you leave the file on the counter, you email a spreadsheet, and the autocomplete has picked up a different John Edwards or something like that. We've all done this. Not all of those things are going to be reportable breaches, but each of them is going to have lessons for you to learn, and it's important to build a process to ensure that you can capture those lessons and improve your practices, and make sure that you're continually calibrating your systems and processes to reduce the risk of a serious thing happening. Because very often, an accidental hit of the send button on an email will mean that the spreadsheet of your clients goes to the one person who's got the biggest axe to grind against you. So make sure that your staff are encouraged to report these kinds of things. Have a culture of encouraging that sort of openness and reporting. Don't punish people. Appoint someone to receive those notifications, to assess whether there's something that can be learned, and whether it is in fact a matter that requires reporting to my office. And you'll find tools on our website to help make that judgment call. Think about updating your privacy statements. I think we've got some commentary and questions on that. And take the chance to use our e-learning. And if you could move the next slide on. We've developed a bunch of modules for online learning. They're free. You can get CPD points for them. They're developed in conjunction with LearningWorks. So they have our subject matter expertise combined with really skilled educational techniques. So the first one that we rolled out, actually, our brief to the developers was to say, we want a once over lightly on privacy. Privacy 101, if you will. So the one in the middle column there at the bottom, Privacy 101 was our first one, the Introduction to the Privacy Act. Well, we got some good feedback on that, but we also got some feedback that said, wow, this is a pretty deep dive. Now, we deal with this stuff every day, so what we thought was just skimming the surface. Some people thought was getting right into the details. So we drew back and said, okay, we need something really simple, really bite-sized, non-technical, non-legal, and we've developed the Health ABC and the Privacy ABC. So if you want to do one thing to prepare for the Privacy Act, get all your staff, the receptionists, the records keepers, the drivers, whoever, to do Privacy ABC. It doesn't mention the law or sections. It's just about instilling those values of respect and raising awareness. And if you do want a deeper dive, do the 101. If you want to just sort of map the changes from the 93 Act to the 2020 Act, have a look at that Privacy Act 2020 up in the top first column there. All right. That's the end, I think, of my prepared materials. I've come in 5 minutes early, which is a surprise for me.
Thanks, John. That was absolutely fantastic. I just wanted to confirm on the last slide, are most of those tools ready for the 2020 privacy update now, or will they be updated on December 1st? That's
a good question. We are going through a process of updating them. Most of them are expressed in a way that they're probably 95% consistent across both acts, and we will be updating, probably adding bits about the breach reporting into the other ones. But if you do the Privacy Act 2020 and the other one in combination, then you'll certainly be ready.
Yeah, fantastic. I just wanted to point out to everybody, we are going to switch gears somewhat, and we're going to focus on some of the topics that might be specifically interested to financial advisors and financial FAPs that will be coming into force in March next year. I did want to make note, the previous two slides, if we can go back one slide, the previous two slides are a really good start for every business. And I think every business should go through and take a look at those slides to get a plan in place for their next steps as they prepare for the first, which people have to be aware that the first is before March 15th when you would become a FAP. So in this next section, we're going to talk about some of the things that might be more directly applicable to advisors and advisor businesses. And one of those things is, if you just want to pop back the slide again, one of those things is when you engage with clients. And financial advisors can engage in clients with on websites, on email, and then in person as well. So what are your expectations for website privacy statements?
I mean, it depends. It depends if the website is your medium for collecting information. If it is a portal for your business to get new clients, for them to register there and provide their AML information and so on, then the expectation is that they get a proper explanation of what that information is going to be used for, and who else is going to see it. So to that extent, the website statement should be the same as the one you get when you walk into an office. If the website is simply a sort of bulletin board, then I guess a declaration of what information is being gathered about the visitors to that site, what cookies you're using, is the sort of European approach. We're not so strict on that in New Zealand, but yeah, I mean, I think you probably should in this day and age be using the website as the sort of central repository for easily accessible information about all aspects of your business. So that, if I want to know what's happening to my information from a financial service provider, I'll go to their website. There should be a pretty prominent button saying privacy.
Okay, fantastic. And a lot of businesses are going to have those considerations. The number of businesses are using their websites to actually gather information, that kind of pushing prospects through and gathering information there. Can we pop over to the next slide, please?
Did you want me to touch on that question on the previous slide about what point should agencies engage on the privacy matters?
Yep, that's fantastic.
So the legal obligation says before collecting information, you should take reasonable steps to ensure the individual is aware of the purposes and so on. So that should be right up front before you sort of start eliciting information.
Okay. Would you say that should be a separate document or an electronic statement that goes out to clients?
Well, the law doesn't specify. It doesn't tell you how to do this. It just says you've got to take reasonable steps to ensure the individual is aware. So all the people on the call will have phoned an insurance company before and heard the pre-recording saying, this information is going to be stored and used for X or Y and Z. That's one way of doing it. The pop-up statement is another way of doing it. The brochure or form is another way of doing it.
Okay, fantastic. Should we pop over to the next slide? Do you need to let people know about everyone that might access their record?
No, I don't think you do. There's, again, I mean, I think a rule of thumb is somebody going to be surprised? Now, when I go to a bank, I expect that there's a whole lot of stuff that's happening behind the scenes that is ancillary to providing me with that service. And so the auditors and insurers, that kind of stuff. But if there are organizations that I routinely disclose information to and intend to, that would not be obvious as part of consuming that service, then I think there's an explicit obligation to provide that. I mean, when you sign up for any kind of professional service, you don't expect that it's going to end in a dispute that will require litigation, right? but maybe 1 in 1,000 or 10,000 does. But that doesn't mean to say you have to disclose to everybody who joins your company. That in the event of a dispute, we will also disclose your information to our lawyers, because that's just an expected part of doing business. You've got a lawyer. You don't have to say, in the event that you default, we're going to disclose it to a debt collector, because again, that's a person that's acting on your behalf in your shoes to carry out an expected function. You're entitled to recover monies that are owed, and you do that either yourself or through the agency of another provider.
Okay. So in that space, you can be quite generic.
Yeah, I mean, I think it's a bit of a theme in the questions that you sent through, Steve, that about the regulatory environment. And I do think that in terms of AML and the sorts of disclosures that you're required to make in that, do need to be explicitly brought to people's attention, that if you are going to disclose to the FMA or the Reserve Bank or whoever else, then that's important. I think it's important to notify some of those contingent recipients as well, such as, transactions that, we are obliged to report transactions that are meet the requirements of the Anti-Money Laundering, Countering Foreign Terrorist Act, that kind of thing.
Yeah, okay, excellent. Can we pop over to the next slide? So we all know that advisors have certain requirements from the FMA to deal with clients' information. We have to keep information for 7 years, and we generally consider that 7 years post the end of the client interaction. And in this new regime, we need to keep information that is relevant. We can't just go out and collect a lot of information on somebody and only keep the part that isn't relevant. John, what are your best practices for destroying information, and how should businesses prepare for not needing that for the end of the holding client information, especially as you interact with kind of large CRMs and cloud providers?
Yeah, I mean, the Privacy Act doesn't say much about this. It simply says you shouldn't retain it for longer than is necessary. And we've in fact seen a case recently where the Human Rights Review Tribunal found that ACC was in breach of its obligation to store information securely by destroying client files that were in some cases up to 20 or 30 years old, because they found that those had an ongoing relevance to the claimant, and therefore they should have been retained, even though they were destroyed in accordance with the sort of non-retention requirement they felt they were under, and the destruction schedule that they were operating. So, there's a balance to be made. I think in this sector, there would not be any obligation to retain the information beyond the regulatory requirements for record keeping, that's 7 years for the Revenue Acts and so on. Identity documents probably don't go out of date, but you should, if you need to refresh your identity verification, then you probably don't need to retain the older versions, that sort of thing. How do you destroy them? Well, securely is a really important component. Don't just stuff files in a rubbish bag and leave them out at the front gate for the dogs to tear apart and to blow down the street. And don't just chuck your servers on a junk heap as well, because those can be, hard drives can be extracted and reconstructed and accessed. So the Privacy Act doesn't tell you when you have to destroy stuff. That's up to you, for your business to determine. The longer you keep it, the sort of greater the risk, in a sense. But if you've got a legitimate business reason to keep hold of it, the Privacy Act's not going to get in your way. If you do decide that you don't need to keep it for longer than 7 years or for some other period, then the obligation is to make sure it's very securely destroyed. There's an apocryphal case of a doctor on the West Coast who was folding up his practice and took a digger down to the beach, dug a big hole and put all his patient files in there for them to be eroded back to the surface fairly promptly and blowing around the coast. So that's not best practice, shall we say.
I've got an example of an advisor in Canada that was burning them in bonfires. Also not best practice. It's something really important for businesses to consider. And in this industry, we've got a lot of businesses transitioning between paper files and digital files, which is bringing these issues up in terms of how do you get rid of the old paper files and how were they stored in the first place, and then moving over to the digital space. But you're seeing a lot of different CRMs, but the CRMs have to have a plan in place to actually get rid of the files at some point when they're no longer relevant and they're more of a risk than they are an asset. And that's something all businesses should be considering as they move forward, and especially into the new regime. Can we pop over to the next slide? Should business data, business and employee data be treated differently from client data?
I think so. I mean, one obvious reason is that you probably need many people in your organization to have access to client data, right? Because you want to have no wrong door. If a client rings and talks to a consultant, they need to be able to access the client data. So you've got wide access internally and a strong perimeter to protect against information. Whereas you don't want all employees to have access to each other's personal information. So you've got to lock down that HR stuff, I think. The non-retention requirements will be different. You don't have that same regulatory imperative to retain. So, you need to write your policy about how long you're keeping employee data. The vetting stuff, you might want to keep a record that you have completed vetting and due diligence on your staff, but you may not need to keep the actual substance. So yeah, how should it be treated? It should be treated with great care. There's a great risk associated with mismanagement of employee data. I think it's really important to give employees access to their personal information so they can say, hey, hang on a minute, you've still got that warning on my file from 5 years ago, and that was a tough time in my life, and our employment contract says if you get 2 warnings within 12 months, there's a consequence, but there's no reason to retain that anymore. Can you get rid of it? So, opening up your staff files and being really open and transparent is a good risk management technique as well.
Yeah, and that's something that's really important for businesses to consider. A lot of times we see a lot of consideration going into client data and CRMs and that kind of thing, but then you ask them about their business data and it's just a bit all over the place.
I think you're frozen, Steve, in accordance with your background. You're melding in with the background.
Or they have absolutely no control. Sorry, what was that?
Sorry, your screen froze for a while and we lost your audio.
Okay. If we can go over to the next slide. I did want to just cover off a couple things. I think we covered it earlier that we can do this more in general in terms of, you can have wider considerations and more generalized statements, but it is important for AML to realize that a lot of you are using kind of EID and things like that. You are actually going out, you're sharing data with other entities, and you have to consider whether or not you need to disclose that. But I think we covered that primarily earlier. If we can pop over to the next slide. One of the things we're seeing in our industry more and more often is data's going overseas and information's going overseas. We all know a lot of the large a lot of our large CRMs are based overseas, but we've got clients that have head offices that they share support services with in Europe. And there's certainly a lot of people starting to use Southeast Asia as support services. What are your considerations for sending that information overseas, or some of the risks you see?
Well, we do have a new principle overseas. You've got to take steps to ensure that it's going to a jurisdiction that has comparable privacy protections. Now, that's quite an onerous burden. If you can't be satisfied, you don't know anything about the law there, or they don't have an obvious privacy law, then the obligation is to ensure the information is protected by other means. The most obvious will be by using model contract clauses. Now, we've developed those. We commissioned Chapman Tripp to write some for us. So those will be available free for anyone in the economy who wants to use them. But I think it's important to clarify when this restriction kicks in, because it's not intended to apply where the recipient agency is simply processing information on your behalf. So my office, for example, we have our entire IT infrastructure sitting on Microsoft Azure in Sydney. Because they are simply holding and processing that information for us, but are not making any separate use for their own purposes, that information, even though it is in Sydney, is deemed at all times to be within my control. So that does not invoke that cross-border. And a lot of SaaS kind of products and platforms will be the same. If the server is in the US or wherever, and they're just providing a service, they're not monetizing or putting offers in front of the individuals, then it's not considered an export. Also, if the recipient agency is separately subject to New Zealand law, then this obligation doesn't kick in. So, for example, if there's a service provider that is clearly operating in New Zealand, but they conduct, their processing function occurs in Singapore or Hong Kong, again, they are already subject to New Zealand law, so you don't need to undertake those inquiries about the law in the destination country, or separately provide for model contract clauses. It's as I say, you need to undertake an assessment of what the recipient agency is going to do with that information. If they're just going to do stuff for you and not do anything for themselves with it, then you probably don't need to worry about it.
Okay, fantastic. Thank you very much. In terms of outsourcing, I think we've just covered that off for the most part. Would you say so?
Yeah, I think so.
Fantastic. And one of the big things businesses are going to have to adapt to, and John covered this earlier, but I just wanted to touch on it again, is clients are going to be able to request their information. And this is something that you're going to have a process in place for as a business. And I suspect you might, like this could come up certainly in complaints and those types of situations, and you're going to have to be prepared to act on that. Do you have anything else to say in that space, John?
Yeah, if that comes as a surprise to anybody on this call, I'd be a bit concerned, because that is not a new innovation of this Act. That has been in place since 1993. And we see a lot of complaints. We're seeing the Human Rights Review Tribunal awarding damages to people when they are not given their information. It's an important one. It's been there since 1993. You've got to be able to respond. Now, the other thing to remember is that very often people invoke that right as the first step when they're in dispute with you. So you might not be feeling very well disposed toward this individual. You've really got to set that aside, and you can't hold their information hostage to unpaid fees or because you got a gripe against them, just set it aside, be professional. You hold this information for business purposes. It's their information. Give it to them. We had a case where a lawyer, a client asked a lawyer for his records. The lawyer said, we've got 3 gigabytes worth. In order to print that all out for you, it's going to cost $19,000. And the client complained to us. We investigated. Now, setting fees, the cost for providing information is one of the few powers I have under the 1993 Act. I can make a determination of what is a reasonable cost. In this case, after I'd investigated, I said, okay, you've got 3 gigabytes worth of files. He's happy to receive it on a USB stick. I fix the $19,000 fee that you've charged at $7.99, which was the cost of a USB stick from Warehouse Stationery. So he was obliged then to comply with that. But the client in that case went on to the Human Rights Review Tribunal and complained about the delay that had been caused by that sort of gaming that the lawyer did. So he had got all the information, but he hadn't got it in a timely way. Now, the Human Rights Review Tribunal went on to award that man $20,000 in compensation for that inconvenience. So not only did the lawyer not get his 19 grand for providing the information, he then had to pay an extra 20 to the guy in compensation.
Yeah, that is a fantastic story. And a great story for financial advisors and people in this industry. I think there hasn't been a lot of visibility around the fact that clients can, and what the rules are in this industry around that. I know questions just come through. Mark, do you want to ask that question?
Sorry, Steve, I've got a few questions that are coming fast here. Which question in particular are you after?
Oh, I think we've just come to the end of the slides.
Oh, okay. So I apologise. I've been in Q&A for quite some time here because we have got a number of questions that have come through. And in answering those questions and passing them on, I'm not sure which ones you've already answered. So I apologise if I ask questions you have already answered. If I can just go through them. The first one, if an agency discloses personal information to an analytical firm so that the analytical firm can perform analysis for the agency, is that for their own purposes of the agency or of the analytical firm? So in terms of whether it's being held by the agency or the analytical firm, whose use is that? Is that the analytical firm's use or the agency's use?
Well, that depends on the facts of the case. Steve, can I just get you to turn off your mic, just so we're not getting any feedback? But that to me sounds like sorry, just frame the question for me again.
Certainly, yes. So we have an agency that collects a whole lot of personal data and they're engaging an analytical firm to analyse those data for them. So if they're passing the personal information on to the agency to do the analysis for them, is that use for the purposes of the analytical firm or for the purposes
oh, right, yeah, sorry. No, I think that's for the agency. The analytical firm is doing something solely on behalf of the other agency. So that seems to me entirely legitimate. It may be that, I mean, there'll be ways of organizing it. It may be that the analytical firm also has parts of its terms and conditions, which allows it to retain that data set to add to its knowledge of, and enhance the analysis it can give across the entire sector. There are exceptions to the restrictions on use and disclosure, where the disclosure is for research or analysis purposes and will not be published in a form that could lead to the identification of an individual. So that would be one way that transaction could be enabled. I would also question whether it's necessary for the analytical firm to have, or at very least retain, identifiable information about the clients. But yeah, I mean, you know, when you're providing services to an agency and that sort, that's entirely allowed.
Lovely, thank you. Next question, or I'm going to skip a couple here, that organizations often have arrangements with offshore business processing outsource providers that can access the organization's systems to provide their services. Is the new Privacy Principle 12 intended to cover this scenario or an external organization?
Yeah, I think we covered that, and the answer is no, it's not intended to cover that. Under the 93 Act, when I give information to you solely for the purposes of processing on my behalf, it's deemed not to be a disclosure. And it doesn't matter whether you are in New Zealand or out of New Zealand, that's how we treat that. It's very explicit in the 93 Act. That provision has been carried over into the 2020 Act. So I don't expect Principle 12 to be engaged in those kinds of services.
Thank you. I think the next question you've covered obliquely in the story.
Sorry. I was just going to say, I think we might have covered the rest of the questions, just taking...
Okay, thanks, Steve. Awesome. Okay, in that case, it's up to me then to thank you very much for your time. We've got a little summary on the screen here of what we've covered. I highly recommend that everybody go onto the Privacy Commission's website and do those e-learns. I did them a couple of weeks ago and found they're really valuable. They get into the detail a little bit more of what those principles cover. So they're highly worthwhile. That you will have as a financial advisor some work to do around updating the documents that you have that mention the Privacy Act to make sure that it's referencing the correct Privacy Act, and a little bit of work that Steve's covered off today. And it's really important that you think about the impacts on your business of where you hold the data, where data is shared with other parties, making sure that you have consents of clients, and particularly where you're outsourcing services to overseas providers, you know, how that data is shared and how it's collected and stored and secured. So up to me to say a huge thank you very much to our presenters. Our next presentation will actually be in 4 weeks' time. In 2 weeks' time, we're right bang in the middle of the Financial Services Council conference. So there's no webinar in 2 weeks' time, but the next webinar will be very helpful for all financial advisors, because what we intend to do is to go deeply into the disclosure regulations and to try and put into plain English what your new disclosure obligations are going to be. And if all goes well, we're also hoping to release some guidance for you to make it a little bit easier to update all of your documentation and prepare yourselves for the new law. So very similar to as you have with the Change in Privacy Act on the 1st of December, you've got a switch you've got to flick to make sure that everything is now compliant with the new law. Similarly with disclosure, on the 15th of March 2021, you'll have to flick a switch and you'll have to suddenly meet all of the new disclosure obligations, and there's some preparation you'll have to do beforehand. So the next webinar on the 30th of October will be a huge help for you to prepare for that. So once again, a huge thank you to Steve Burgess again, and a massive thank you to John Edwards. It's been lovely to have you and very nice to meet you. I appreciate very much your time. Please pass on the recording information about this webinar. Anybody who missed it will be able to see it on YouTube. It'll be available in the next couple of days on the YouTube channel. Thanks for coming, everyone, and we'll look forward to seeing you again soon.